Minister Rona Ambrose and Minister Bernard Belcourt this morning. We certainly appreciate you taking time to be with us. We know you are busy, busy people, so we feel very special that you're giving us time to be with us today. You each have 10 minutes to begin, and either of you can begin whenever you are ready.
Madame la Présidente, merci beaucoup.
Thank you very much, Madam Chair. Thank you for the opportunity to appear before this committee charged with studying Bill S2, an act respecting family homes situated on First Nation reserves and matrimonial interests or rights in or to structures and land situated on those reserves. I'm accompanied by my colleague, the Honourable Rona Ambrose, Minister for Status of Women. In the context of your work, we are very interested in contributing.
I will start hard by saying that, by asking you all, parliamentary colleagues and Madam Chair, to allow me to first express my consternation and my incredulity at the arguments I have heard in support of the opposition to Bill S2. And if I can also characterize this opposition. What I've heard in the House at second reading from the opposition party spokesperson, I've heard them dressing up the bill with a lot of concerns that we all share about the situation of too many First Nations in this country. I mean, whether it be housing, whether it be water, access to roads, to electricity, to access to legal services, or the health of First Nation community members, the suicide rate on reserves, or access to education and employment opportunities, these are all concerns that we all share and that have been raised in the course of debate to object to the enactment of Bill S2 as law in this country. But why oppose a bill about family homes on reserves and matrimonial interest and its remedial provisions? Because that legislation does not address other concerns. This Bill S2 is not about housing, it's not about water, it's not about access roads or to electricity or water or access to legal services or the specific health problems that First Nation members suffer from. It's about the rights of married or common law couples living on reserve in the case of breakup of their relationship or their death. It's about an equitable division of these family assets, and in the case of violent and abusive relationships, protecting a spouse or the child or children, if any, by allowing the court to grant an individual exclusive occupation right to the family home to that spouse. So after you address the bill of the concerns expressed, which the bill is not aimed at, but for what it really is, you end up with the pure, simple question of equality of status for couples and families on reserve in case of conjugal relationship breakdown, and with that of other Canadian couples not living on reserves. I mean, many Canadians are not aware, for example, that in the absence of legislation like Bill S2, a spouse who holds the interest in an unreserved family home can, on his own, on her own, sell that home without the consent of the other spouse and keep all the money. Or that spouse who holds the interest in the family home can bar the other spouse from their home on reserve without regard to the welfare of the spouse and the child or children, if any. Or that in the event of domestic violence or abuse, a court in this country cannot order exclusive occupation of the family home to the spouse who holds the interest in the unreserved family home, even on a temporary basis. And these rights are available to all other Canadians who do not live on reserve, whether they are Aboriginal people or not. So it is simply unacceptable, I submit to you with respect, that in this day and age, people living on reserve are not afforded the same rights and protections as those living off reserve. And individuals living on reserve should not be penalized simply because of where they live. Yet, for more than 25 years since the 1986 Supreme Court decisions in two particular cases, Paul versus Paul and Derrickson versus Derrickson, Aboriginal women and children living on reserve have had no rights to matrimonial real property. For them, the breakdown of a relationship or the death of a spouse or common law partner can mean insecurity, financial difficulties, or homelessness. Lorsque les membres du comité sanitaire
When the Standing Senate Committee on Human Rights studied Bill S-2, they heard firsthand from several courageous individuals who came forward to tell their stories, awful stories, about how they had personally suffered the consequences from the lack of legislation governing matrimonial real property on reserve. Bill S-2 not only responds to calls for action from Aboriginal women, but also international organizations, as well as parliamentary committees. Even Manitoba's NDP government understands the urgency of the situation. They are in power now, the NDP in that province. The clerk of the Legislative Assembly sent me the unanimous motion passed in Manitoba urging the swift passage of this federal legislation of S2. And this motion, the provincial MPPs passed it unanimously, calling upon us to pass S2. This bill, and I heard it said in the House, is not paternalistic, and it isn't dictatorial either vis-à-vis First Nations. But I would submit to you that not passing it would be. Under this legislation, First Nations can either choose to enact their own laws related to matrimonial real property rights and interests, laws designed to meet their particular needs and respect their particular customs and culture, or they can choose to follow the federal rules. By empowering First Nations to develop their own laws in this area, Bill S2 respects the diversity that exists among First Nations. First Nations can adopt community-specific laws that may offer different and effective means, depending on the choice of that First Nation, different but effective means of addressing matrimonial real property issues on their respective reserve lands. The legislation would also ensure that until such time as a First Nation is able to create its own laws, federal rules would provide families with the rights and protections they seek and deserve, just like all non-Aboriginal citizens and Aboriginals living off reserve. As a result, all men, women, and children living on reserve will have equal rights related to the occupancy, transfer, or sale of the family home that were not previously guaranteed to First Nation members living on reserve.
In situations of family violence, a spouse can now apply, with the benefit of this act, for an emergency order to stay in the family home at the exclusion of the other spouse for a period of up to 90 days, with the possibility of extension. These provisions will allow victimized spouses or common law partners in abusive relationships to ask for exclusive occupation of the family home for a specified period of time, providing victims and their dependents with a place to stay. And we have committed, as you all know, I hope, to the creation of an arm's-length Center of Excellence for Matrimonial Real Property, which will assist First Nations in the development of their own unreserved matrimonial real property laws or in the application of the federal provisional rules. Madam Chair, our government has undertaken an extensive 2-year consultation process that included over 100 meetings in 76 sites across Canada, and we have had ample opportunity to review, discuss, and debate the bill since it was introduced in 2008. Time is flying, so I will allow my colleague, Minister Ambrose, to get their 10-minute shots also. Thank you.
Thank you. Thank you, Madam Chair, and thank you to the committee for your work on this matter and the opportunity to be here to participate in the committee's review of Bill S2. As Minister for Status of Women, I feel strongly that this legislation will provide options to women and children living on reserve who are experiencing family violence. Wives, spouses, or common law partners that are living on reserve face the reality that, in the event of separation, divorce, or death, the law currently does not protect their matrimonial real property interests or rights. As Minister Valcourt indicated, it's been over 25 years since the Supreme Court of Canada identified this shocking legal gap. This is now our government's 4th attempt to pass this legislation. Our government is committed to ending violence against women and girls in communities across Canada, and this legislation is part of that process. We are taking action to protect those most vulnerable in Canadian society: women in immigrant communities, women living in poverty, and Aboriginal women and girls, through essential women's projects, but also through legislation like Bill S2. Bill S2, which you know is the Family Homes on Reserves and Matrimonial Interests or Rights Act, will guarantee the matrimonial real property rights and interests of women who live on reserves and will protect spouses from violent domestic situations. Most Canadians do not know that Aboriginal women on reserve do not share the same basic right to property as women who live off reserves. This legal gap has led to the suffering of countless Aboriginal women. Their suffering makes it clear why we need this bill to be passed by Parliament this spring. These women have waited not long enough. I urge all parties to vote in favor of this bill. Statistics show that Aboriginal women are almost 3 times more likely than non-Aboriginal women to report being a victim of a violent crime, including spousal violence. In 2009, close to 2/3 of Aboriginal female victims were aged 15 to 34. This age group accounted for just under half of the total female Aboriginal population over age 15, living in 10 provinces. And among victims of spousal violence, 6 in 10 Aboriginal women reported being injured. For comparison, the proportion was 4 in 10 among non-Aboriginal women. According to Statistics Canada's Women in Canada report that was published in 2009, 15% of all Aboriginal women who were married or in a common law relationship had experienced spousal violence in the previous 5 years. The rate in the same report among non-Aboriginal women was 6%. Our government has taken several actions to eliminate violence against women and girls. We've invested over $11 million in funding for projects specifically to end violence against Aboriginal women and girls just since 2007, and $19 million in the same time frame on projects to empower and protect Aboriginal women and girls. Our government proposes to close this rights gap in the matrimonial property rights law once and for all with the passing of this act. This legislation is about eliminating an injustice by giving on-reserve women, including the victims of violence, access to the options that are available to other Canadian women. I'm, of course, particularly pleased, and I know that all of you would be interested, that this bill will provide emergency protection orders to Aboriginal women and children who are abused. Emergency protection orders save lives. Recognized by child and family justice advocates as one of the most significant means of preventing family violence. Sadly, as I mentioned, we know that Aboriginal women are more likely to experience spousal violence when compared to non-Aboriginal women. Aboriginal women on reserve who are not able to stay in the family home are forced to flee the reserve with their children, sometimes with nothing more than the clothes on their back. As it stands today, a woman living on a reserve who is a victim of violence has no legal protection other than pressing criminal charges. There is no mechanism to allow a parent and children exclusive access to a family home. Again, I repeat, emergency protection orders save lives. In the case of domestic violence and physical abuse, a court cannot order the spouse who holds the interest in the reserve home, which is usually the male partner, to leave the home, even on a temporary basis. When a woman and her children are evicted from a family home on reserve, no judge has currently the power to intervene. Extending the same rights women off reserve have to Aboriginal women living on reserve will address this dire situation. For women in the rest of Canada who are not living in this situation, and when faced with family violence, this situation is much different. When emergency protection orders are enforced, as you know very well, abusers can be removed, allowing the women and children to find safety in the comfort of their own family home. If Aboriginal women are granted the ability to remain in the family home on reserve, they can escape situations of domestic violence while continuing to care for their children and maintaining vital access to the support of their community. Again, importantly, emergency protection orders save lives. In addition to the protections provided by these orders, Bill S2 also provides for the granting of a temporary exclusive occupation of the family home. This protection is twofold. Firstly, in situations of family violence, women can be granted temporary exclusive occupation of the home for a period of time extending past the emergency occupation. Secondly, in the case of the death of a spouse or common law partner, the surviving spouse is allowed to stay in the home for 180 days. During that time, the surviving spouse may apply for exclusive occupation of the family home for a period of time to be determined by the courts. There's been a need for this bill for a quarter of a century. Our government has brought this issue before Parliament 4 times now, debating this issue in both chambers and in committee now for over 50 hours. This includes more than 15 hours of debate on this particular bill alone. And yet, after spending $8 million on 103 consultation sessions, as Minister Valcourt spoke to, in 76 different communities across Canada, and after countless reports and studies going back a quarter of a century, the opposition are proposing more talk. But we say that it's time to move forward. We say it's time that Aboriginal women living on reserve share the same rights as all other Canadian women. And this committee has the power to do exactly that. Members of this committee in particular have first-hand knowledge of the nature and extent of the problem, having recently studied the issue of violence against Aboriginal women. You have heard the stories from Aboriginal women and are aware of the factors that contribute to violence in their lives. This committee has a special understanding of what is at stake here. As the Minister for Status of Women, I've sought to address violence against Aboriginal women by supporting many projects that address violence in a comprehensive manner and building economic security and developing the leadership skills that prepare women to successfully escape violent domestic situations. As I mentioned earlier, since 2007, through the Women's Program, we have provided funding for more than $90 million in support of projects that help to empower and protect Aboriginal women and girls. For instance, in the Yukon, the Liard Aboriginal Women's Society is helping Aboriginal women transition to violence-free lives by building relationships between Aboriginal women, law enforcement officials, and local service providers. These often neglected relationships between Aboriginal women and service providers can make the difference between service providers or law enforcement officers overlooking, or recognizing a violent domestic situation. Similar work is also being done to prepare law enforcement officers at the community level through the development of protocols, law enforcement orientation documents, and community safety action plans. Our government is also supporting women who have been the victims of violence through projects like that of the Creating Hope Society in Alberta. Their projects specifically supporting First Nations women and girls that are living on reserves within the Edmonton city limits who have experienced violence by engaging First Nations groups, service providers, and women and girls themselves. Actions taken to end violence against women and girls by this government include increasing funding to the Women's Program to its highest level in Canadian history, funding over 600 projects now in Canada since 2007, launching a comprehensive national action plan to combat human trafficking to ensure the safety and security of women and girls across Canada who are being targeted for sexual exploitation by violent traffickers. We've also developed a 5-year national strategy aimed at enhancing the response of law enforcement and the justice system to cases of missing and murdered Aboriginal women and girls by supporting culturally appropriate victim services. And, of course, this bill, Bill S2, that will give Aboriginal women equal rights and access to their matrimonial property rights and emergency protection orders in the cases of domestic violence. So in conclusion, Madam Chair, let me reiterate that this legislation is about eliminating an injustice. It's about closing a legal gap that creates inequality and leaves Aboriginal women vulnerable. It's about ensuring that all Canadians, whether they live on or off reserve, have similar protections and rights when it comes to family homes, matrimonial interests, safety, and security. In the course of your committee's deliberations on this bill, I urge members to consider the previous testimony, of which there's been quite a bit, by Aboriginal women and leaders across Canada, such as that provided by Betty Ann Lavallee, National Chief of the Congress of Aboriginal Peoples. She said about Bill S2, Bill S2 is addressing the real human issue of an Aboriginal person, something taken for granted by all other Canadians. A spouse within an Aboriginal relationship should not be denied or put out on the street alone and without any recourse because of a family or marital breakdown. And I agree completely with her statement. Her words are informed by her knowledge of the often harsh realities of day-to-day life faced by many women residents of First Nations communities. At the end of the day, Bill S2 is about taking action also. It's been over 25 years since the Supreme Court of Canada identified this legal gap, and our government is closing this gap with this bill. Bill S2 proposes an effective solution to this injustice, and we hope that all members on all sides of the House will support this initiative moving forward. Thank you, Madam Chair.
Thank you for your great presentation, and we will begin our rounds of questioning, beginning with Ms. Troupe for 7 minutes.
Thank you, Madam Chair, and thank you, Ministers Velcourt and Ambrose, for being with us today to discuss this important issue. The issue of the lack of matrimonial property rights on reserve has been raised a number of times in the last 25 years, and we've seen 4 independent reports and 3 parliamentary committee studies on this topic, all of which were calling for legislation to fill this legal gap. Minister Velcourt, could you explain the gap between the current provincial and territorial legislation and the current situation on reserve with regard to matrimonial property rights?
Well, you know, as alluded to earlier, the gap is the fact that since the Supreme Court of Canada rendered those decisions 25 years ago, the impact and the effect of those decisions was that any Aboriginal spouse living on reserve who in the past were attempting to use the benefits of matrimonial property law at the provincial level or the territorial level had accessed these legislation and the benefits from it on occasion. But the Supreme Court made it clear that these provincial and territorial legislation did not apply to Aboriginal people living on reserve. So First Nation communities that are reserved under the Indian Act do not get the benefit. And that's the gap that S2 is trying to fill. And, you know, for many, many years, and this government has been at it now for a number of years, so we believe it's time that the gap be filled.
Thank you. I can't believe that the Supreme Court did that to Aboriginal women. What will the legislation do?
Well, you know, in your comment in regard to the Supreme Court is bound by the law of the land, and the Constitution is clear as to the allocation of powers in between the federal and provincial government. So what this legislation does, and it is important that the committee considers this. I mean, you know, it's there are two sides to this. The first one is that there are provisional rules that will apply throughout First Nation communities, but they are provisional until the First Nation itself adopt its own laws, which they can. I mean, the reality of First Nations in Canada is that they are different. They have different cultures. They have different customs. And now with this bill, those who choose to do so will be able to draft and pass their own laws, which will be endorsed and approved by the community, and then applicable on reserve. So that's why I said earlier, this is not at all paternalistic. I mean, this is giving the First Nation communities the powers to adopt laws that will deal with the very issue at the heart of S2. Now, for those who don't, then the federal rules will apply. And we know that this will not happen overnight. That's why we have this 1 year period from the day that the bill receives royal assent. For 1 year, nothing happens. The First Nations who want to adopt during that year their own laws will be able to do so. They will come into force 1 year after royal assent, just like the provisional federal rules will. And at that time, either the federal law applies or the local community law applies. So I think it's a practical approach to a difficult problem in terms of implementation. And what you have to know also is that the Center of Excellence, which will be set up after the royal assent is given to the bill, will help First Nations into developing these laws for their own communities.
Thank you. Legislation on the topic of matrimonial property rights on reserve has been introduced into the House and Senate 4 times in its various forms and has been debated for over 40 hours in the House of Commons, Senate, and at committee. 103 consultations were held across the country in 76 different locations over the period of the drafting of this legislation, and I was hoping you could speak to the pressing need for this legislation and the importance of resolving the issue as soon as possible.
Let me put it succinctly here. Every day that passes is one more day that women and children living on reserve do not have access to the same protections offered those living off reserve. We should not have second-class citizens in this country.
Thank you, Mr. Vilcour. I'm good. Thank you. No, I'm
Okay.
good.
Moving to Nick Ashton for 7 minutes.
Thank you, ministers, for joining us today. We recognize that that there is a legislative gap that is important to address. There's no question. But we have real problems with the lack of consultation, the lack of respect for First Nations jurisdiction. We've worked closely with the Native Women's Association of Canada and the Assembly of First Nations that have expressed real concern about this piece of legislation. And of course, First Nations across the country who also oppose this legislation. I'm wondering, both Minister Valcourt and Minister Ambrose, did you consult with all First Nations across Canada around S2?
Well, I'll just speak quickly to some of the issues around addressing violence against women. I'll let Minister Valcourt speak to the actual consultation.
I'm more interested in the consultation, actually. That's
well,
the piece.
one thing that I would like to share with you is Michelle Odette was one of the witnesses who is now the president of the Native Women's Association of Canada. And during her testimony, she said, "We are giving this bill a favorable reception because it will put an end to the legal vacuum. It will protect women with regard to family and spousal violence," end quote, which I think is, for this committee, is a really important issue. When Minister Valcourt and I talk about the access to emergency protection orders and access to exclusive rights to the home, as I said, family justice advocates say that emergency protection orders, and we all know this as women that care about ending family violence, saves lives and is one of the most significant tools that we can use to prevent family violence. So I'll end there and allow Minister Valcourt.
Yeah, and again
to speak
on the
about
consultation, because that's the point I didn't hear.
On the consultation issue, I mean, it was this government that initiated, you will remember maybe, a 4-phase comprehensive consultation process starting in 2006 and ending in October 2007. The national consultation phase took place from September 29, 2006 to January 31, 2007, and that's the one that included 103 sessions in 76 sites. Over $8 million was spent on the process conducted by the Native Women Association of Canada, by the Assembly of First Nation, and Aboriginal Affairs and Northern Development Canada. So it was not a consultation that the department made only. The Native Women Association of Canada and the Assembly of First Nations each received $2.7 million for their participation in the consultations.
Mr. Minister, and with all due respect, I mean, I appreciate the figures and the timelines, but the question is here, there are over 600 First Nations in Canada. Did the Department of Aboriginal Affairs and you as Minister, your predecessors, consult with every single one of these First Nations, yes or no?
Did we consult with every woman before we gave them the right to vote? I mean, seriously, you want to is this a question you think we should continue to consult on equality of rights for women?
Minister
Access to emergency protection orders, you want to continue to consult. We've consulted for 25 years.
I don't think the questions are supposed to be directed to me. I think this is our opportunity to ask you the questions. And my question is very simple and around respect for First Nations jurisdiction. First Nations women have treaty and Aboriginal rights, and those rights need to be respected. This government, I mean, you know, it's your government that signed on to the UN Declaration of Indigenous Rights, and in that declaration, there is a duty to consult, and that we find it egregious that consultation, that proper consultation, hasn't taken place. But let me move on to another topic, because I understand, Ms. Ambrose, that the issue of violence against women is something that you've expressed real interest in. My question is, and perhaps to both of you ministers, but your government, I mean, if you're so interested in violence against Aboriginal women, why not listen to the families of missing and murdered Aboriginal women and call a national inquiry into missing and murdered Aboriginal women?
You know, on the issue of consultation, and you come from the very province, maybe you should listen to your father. I mean, they told us...
Excuse me, Mr. Minister.
They told us clearly,
Madam Chair.
And this is Manitoba. The Legislative Assembly of Manitoba prayed us, exhorted us to pass Bill S2. If there is a province where there is an important Aboriginal community, First Nations, who are experiencing serious issues and problems, it is Manitoba, among others.
And Mr. Minister, I'm sorry, because I feel offended by the comment that you've made.
The duty to consult.
And Madam Chair,
this is not about the duty to consult.
Point of order. Point of order. I mean, if we're talking about paternalism, it takes many forms. And asking me who I talk to and don't talk to from my family is not part of what we're talking about in this committee.
Madam Chair.
And I would ask the kind of respect that I'm showing to the witnesses from the witnesses as well.
It's not a point of order. Commissioner said it right away. Go ahead. It's not a point of order.
Okay.
I think it's important to clarify here that this is not a paternalistic comment.
No.
If you know, the individual who has been referred to is a member of the government of Manitoba who has sought the support of the federal government for this issue.
We're going to carry on with the minister. Mr. Minister.
Listen, I want to be clear. You know, I did not want to sound paternalistic, and if I have offended the member, I sincerely apologize. My point is simply this, okay? We have been exhorted by the province of Manitoba and by others across Canada to give spouses on reserve the same rights that other Canadians enjoy. This has gone on, this gap, you acknowledged it in your introductory question. This is a gap that has been in place for 25 years. And I still wonder why we want to wait any further. I mean, the inherent right, and you know this better than I, the inherent right to self-government, okay, is not the answer to filling the gap. Right now, the constitutional provisions we have, the Indian Act we have all inherited, I mean, makes it impossible for First Nations, unless you are one under the land management system, to pass these laws. So this is about trying to fill a gap in the best reasonable way and finally give these couples on reserve the same rights that you and I enjoy.
Just quickly, both Mr. Ministers, Mr. Minister, Madam Minister, for us this is an issue that unfortunately your government has chosen to play politics with. We believe that proper consultation with First Nations needs to take place. We also believe that there needs to be measures to remedy a national inquiry into missing and murdered Aboriginal women, the shocking lack of housing that leads to tensions amongst families, the poverty, extreme poverty that exists in communities, the lack of education funding, and the list goes on. And that's the kind of action we'd like to see from this government.
Moving right along to the next question, Roxanne James.
Thank you, Madam Chair, and thank you to both Minister Ambrose and Minister Valcourt for being here today and speaking on S2. I know that both of you feel very strongly about this particular piece of legislation, as do I. In fact, this past weekend, I spoke to my husband about this very bill. I spoke to my husband about the current situation for Aboriginal women on reserves and what this legislation will mean to each and every one of those women. And I know that Mr. Valcourt, in your opening remarks, you talked about in this day and age, and my husband said the exact same thing. He looked at me like I was speaking a foreign language. He could not believe that in this day and age in Canada, Aboriginal women on reserves do not have the same interest and access to matrimonial property as do every single person in this room today. He was shocked. And I'm going to be honest, and I apologize for getting emotional, but as a member of the Standing Committee for the Status of Women, this is a priority. We have to pass this legislation. And I know, Minister Ambrose, one of the things that you said in your opening remarks that you consider to be the most important aspect of this bill is the access to emergency protection orders and temporary exclusive occupation orders. I agree with you on that. I think it's paramount. I think that we need to protect women, and we need to make it happen now, not another year, not another 2 years. We need to pass this legislation now. In your opening remarks, like my husband, and I'll be honest with you, before I became a member of Parliament, before I read into this bill, and before I understood the breadth of what this would mean to Aboriginal women, I had no idea that there was such an inequality issue on reserves and that there was this legislation gap. I was also shocked. Most Canadians are surprised. I think that most Canadians listening right now today to this committee would be shocked and are surprised to hear of this legislation gap. And I think that they're standing behind this government to make sure this legislation goes through. But I want to speak directly to Minister Ambrose. I'm going to direct this question to you. And it has to do with the protection of a violent spouse in your own home, which is not extended to Aboriginal women currently on reserves. If someone were to break into your home right now, hopefully not in my riding of Scarborough Centre, but in any riding across this country, and became violent or abusive, the police would be called and that person would be removed. That's a given. No one would question that. When a spouse becomes violent and abusive, they should be the ones removed from the family home, not the victim of violence. And yet on reserves, the complete opposite is true today. And I think Canadians need to understand that and know that the impact of this bill is going to protect those women. In cases where the need for protection is extended and where there are children that are involved, having access to or extended access to the family home is extremely crucial. It's important. Bill S2, in addition to providing access to emergency protection orders, also allows the courts to take these factors into consideration and provide extended, exclusive occupation access to the family home. This is paramount. We need this legislation. And I'm just wondering, Minister Ambrose, if you could speak more. I know you did in your opening remarks, but if you could speak in more detail to the need for emergency protection orders on reserve and the need for access to temporary exclusive occupation orders. Thank you.
Sure. Well, thank you for your comments. I know I'm repeating myself, but emergency protection orders save lives. Anyone who works in the field of any violence against women, any workers that frontline service providers at shelters, police officers will tell you that they are one of the most important tools to preventing family violence. And of course, as you indicated, Canadian women have access to a number of legal protections right now that are not available to men and women living on reserve. And as I said earlier, Aboriginal women are 3 times more likely than other Canadian women to experience violent crime, including spousal violence. So the emergency protection orders that are provided in Bill S2 are very important because they extend these protections to women and children living on reserve. Bill S2 also gives First Nations Band Council the ability to create their own legislation, which I think is important, as Minister Valcourt said, related to matrimonial property rights and to enforce these orders on reserve. Should they not, then obviously the federal regulations would stand. I just wanted to go through a little bit of the process because there's been a lot of thought has gone into this. It's been 25 years. We've tried 4 times now to pass this legislation. And there's been a lot of consultation with First Nations, with the Native Women's Association of Canada, as Minister Valcourt indicated. But when it comes to emergency protection orders, any spouse or common law partner, whether or not that person is a First Nation member or will be able to make an application to a judge or justice of the peace for an emergency protection order. And that's incredibly important, as you said. The person seeking protection will not need to be occupying the family home at the time that they make the application, which is also important. A peace officer or any other person will be able to make the application on behalf of the person seeking protection, again, also very important, of course with their consent, but can also make the application without the person's consent if they have the permission from the judge or the justice of the peace. Again, those of you who are involved in issues around preventing violence against women know why this is also very important. The application will be able to be made ex parte, which means that it is a proceeding that only involves the person seeking protection and does not involve representation or notification of the other spouse or common law partner. Again, very important for a woman who's going through issues around domestic violence. If the designated judge is satisfied that family violence has occurred and that the victim is at risk and in need of protection, he or she will be able to make an order excluding the other spouse or common law partner from the family home for up to 90 days, as well as other measures that the designated judge considers necessary for the immediate protection of the victim or of the property that is at risk of damage. Again, this is what all of us are used to dealing with when it comes to domestic violence in every other parts of the country, but on reserve, this is not the case today. In making the order, the designated judge will be required to consider the broader details and circumstances surrounding the family violence, including, for example, the history and nature of the violence and the best interests of any children. A peace officer will be able to serve a copy of the order on any person who is specified in the order, and a person is bound by the order as soon as they receive notice of it. The peace officer will also let the applicant know that the order has been served on the spouse or common law partner. The contents of the order may, for example, direct the peace officer to remove the spouse or common law partner from the family home. Emergency protection orders are often the initial procedures in a relationship breakup, which would be followed by application for exclusive occupation and valuation. One of the greatest hardships on women fleeing a violent family situation is that they often leave with only the belongings on their backs, often to a shelter, and with no long-term housing. Bill S2 will ensure that women seeking protection from a violent spouse will not be re-victimized by the need to run, often to the nearest town or miles away. In addition, thank you. So obviously, you know how I feel about emergency protection. Every day that goes by without passing this bill, these women have less protection.
Now we move to Madam Squirrel for 7 minutes.
Ben is replacing me on committee today.
Okay, so thanks very much. In 2006, Minister Prentice appreciating the complexity of this issue, appointed Wendy Grant-John to do the study. And in her report, she proposed that there would need to be standalone federal legislation. But in her final report, she actually said, the viability and effectiveness of any legislative framework will also depend on necessary financial resources being made available for implementation of non-legislative measures, and without these kinds of supports from the federal government, matrimonial real property protections will simply not be accessible to the vast majority of First Nations people. So I think that, I think as my colleague has said, that we on this side agree that the legal gaps need to be filled, but without doing what the ministerial representative recommended. And I remember when the report was tabled, there was a huge caution from all across this country not to cherry pick her report. You had to do all of it, not just one bit. And so I guess my first question will be that unfortunately it seems that Wendy Grant-John's not being able to speak freely. Will you allow Wendy Grant-John to appear before this committee?
Yeah, well, I,
The opposition member can ask a witness whether they're going to allow someone to appear before our committee. That's the
She
decision of the
cannot,
committee.
well, maybe the members should understand the issue. Maybe I didn't explain myself properly. Wendy Grant John cannot speak publicly without the minister's permission.
I know.
So will she have the minister's permission
Well,
to
listen,
come before this committee?
Let me be very candid. I'm not aware of the status of Madame Wendy Grant John. I don't have the privilege of knowing the lady, but this is something I can look into. I don't know.
That's great. At the same time, in 2006, the department commissioned the Johnson Report, which was looking at shelter funding methodology on reserve. And according to it was to bring the on-reserve shelter up to the par with other shelters in Canada. Unfortunately, according to the 2011 report commissioned by the Alberta Council of Women's Shelters, it determined that the 6 on-reserve shelters in Alberta were underfunded by approximately $2.2 million in just 2010, 2011. So I guess I need a commitment from the minister. Can you get the shelters on reserve at least up to par?
Well, I did not prepare to discuss shelters today. I prepared to discuss this bill. But surely I can take note of your question and get back to you, Madame Bennett.
Okay. The other issue that Wendy Grant John alluded to, and I think that as you know, the reason that we have withheld support for this bill is because Native women across the country are feeling it will not solve the problem on its own, and that we actually need to see the full suite of initiatives in order to give support. And one of, you used the word not afforded the same rights, Minister, but I think that what we're hearing from Native women across Canada is that they can't afford to access the rights that actually would be present in this legislation. So it means that if you kick this to a provincial system, and if there's not the capacity within First Nations to do alternative dispute resolution, there's not capacity to keep women on the reserve where they prefer to be, and again, build the capacity First Nation by First Nation, that again, they will not be able to have access to the provincial courts, and they won't have access to ensure the expertise to deal with the unique legal and cultural issues regarding First Nations.
Let me answer you in 3 ways. First, as you know, there will be a center of excellence created in order to do just that, deal with the capacity.
When would that
and
be?
give, this will be when the Act receives royal assent. After it has received royal assent, we will establish this center of excellence.
Was the money in the budget?
To do that, to help the communities, the First Nations, to pass the laws. Now, coming back to your other argument about the access to, let me characterize this as legal aid. I was a member of the bar in New Brunswick when the first Matrimonial Property Act was passed, and we got this same argument from several men who were opposed to the bill because, many women would not have the legal resources or the financial resources to access the benefits of that law. Well, the experience in all provinces, not only New Brunswick, is that all of the married couples, especially women, have benefited greatly, even if they didn't have the financial resources for these high-priced lawyers. So, it's not a concern I share with you. And in regard to your, I find it astute that you said that you were withholding your support of this bill. And I don't want to be political or utterly too much political. But on the second day of your new leader being in the House, I thought it rich when he stood up to talk about the Charter of Rights and Freedom, and then instructing his caucus to vote against this bill. I think that this, at issue here, when you, and I don't dismiss the concerns you have about, I don't dismiss the concerns you have about the other side issues that do influence this. But the fundamental question is equal rights for women and children on reserve.
J'accepte mon
And that's
I accept my role as spokesperson.
of Native women across the country. They do not feel protected by this bill without the other issues dealt with. And also, I mean, maybe there's something simple you could help me with then in creating the potential for open-ended interests for non-First Nations individuals on reserve. Can you address that concern?
I mean, this is a this is a concern addressed in the bill because, as you know, the bill allows First Nation Council to intervene in the court process that will decide those issues, and these are considerations that are legislated in the bill and that the court will take into account, just to avoid the problem that you raise.
Okay. Thank you. Moving right along to Ms. Bateman for 5 minutes.
Merci, Madame la Présidente, et je vous remercie.
Thank you, Madam Chair, and thank you to Ministers Ambrose and Valcourt for participating in our study of Bill S2. This is a bill that is very important.
Your utter incredulity. I share your utter incredulity with the fact that this legal gap has existed for 25 years. And if my colleague's husband was incredulous, I can't even describe the shock my 15-year-old daughter has that this is the law in Canada. So I'm delighted that you're helping us all to change this. This legislation is quite unique, though, because it's interacting alongside both provincial, territorial legislation. It has to take into account the First Nations law and the First Nations Land Management Act. And so, obviously, there are a few First Nations who have been proactive and who have changed this in their own communities. But the vast majority of First Nations are not protected. There remains a legislative gap. And, I've got a few questions which either minister, as you wish, can respond to. First of all, I think I'd like a little bit more information on how S2 is allowing First Nations to enact their own laws on the topic of on-reserve matrimonial property rights. I'd like to add that I know, notwithstanding the colleagues' comments from the Liberal Party who indicated that shelters are preferable, they really aren't, in my view, as a mother. I think in the case of a marriage or a family breakup, it's always preferable for the child to stay in the home, regardless of which parent stays with them. And then the other question is, could you describe how this bill will apply to First Nations, including those who are already under the First Nation land management regime and self-governing First Nations?
Okay, well, briefly, right now, and you rightly point out that, some First Nations, current First Nations, will be accepted from application of this Act. First, those who have concluded self-government agreement where they have already the power to enact laws in regard to matrimonial property. We have canvassed those. They have. And these laws are working perfectly well. They are in line with the rights that other women and other couples in Canada enjoy in case of marriage breakdown or at death. And as to the ability of First Nations to pass these laws, well, the Act is clear about this. But what is, I think, more important is that the provisions are culturally sensitive in that and we know that First Nations have different customs, different culture, in regard to their day-to-day life, and they will have the power under the Act to propose to their community members a law that is respectful of their custom, of their culture, and we think that this is an important aspect of this bill. And, you know, I share the concern expressed by the opposition members, and I've heard from our caucus members also that the timeline during which they will be able to pass these own laws, you know, is a concern. And that's why, and that's where the Center of Excellence comes in, because we think that they can do an enormous task with the First Nations to help them develop these laws so that they be in effect as soon as the First Nation determines they are.
Right.
You want to add something?
Well, I mean, I would just continue to add the urgency around the need to implement family protection orders and address an issue, a legal gap when it comes to dealing with violence against Aboriginal women and girls on reserve. I mean, I've said it repeatedly, but every other Canadian woman in this country that's not living in this situation on reserve has access to legal protection that Aboriginal women and girls on reserve do not have access to. And when we look at the statistics around violence against Aboriginal women and girls, it's very, very concerning that we don't have those. You know, it's about prevention and it's about intervention and about prosecution. And that's how we end violence against women, and we don't have that right now on reserve. So I urge all parties to study this bill, but also to pass it as quickly as possible.
Okay, thank you. Moving on to Jane Crowder.
Thank you, Madam Chair, and good to see the ministers here on such an important matter. And I guess where we would all agree is that it's well past time to deal with the issues of matrimonial real property. Where we would disagree is the methodology. And I just want to add a bit to something the minister had said about testimony that Michelle Odette from the Native Women's Association of Canada provided. She also went on in her testimony to say, once again, I love blackberries. She said in her testimony at the Senate that once again, after everything that our sister here has been through, yes, it is a salve, but if our communities do not have the financial, human, and material resources needed, it is going to be a failure. When you live far from urban centres and you wait a long time for a sentence, a decision, or some protection, you just give up and say, what is the point in filing a complaint or reporting something? So just to be clear that Madame Odette did not give unqualified support to this bill. She raised grave concerns with the ability of First Nations communities to actually implement the bill. I know you're very familiar with this process, so I'd appreciate a yes or a no answer to my next question. Did either of your departments conduct a constitutional Section 35 analysis about whether this bill would infringe on Aboriginal rights and title? Just yes or no would be fine. Minister Ambrose, did the status of women?
This is something that I'll let Minister Valcourt.
Absolutely. I mean, every piece of legislation that is submitted to the Parliament of Canada is subjected to a Section 35 assessment.
Great. Would you be able to provide that analysis to the committee members so we could review that Section 35 analysis?
The legal advice given to ministers is privilege.
Okay, so we'll have to look elsewhere for whether we think there's been an infringement.
Yeah.
With regards to the ministerial report of the ministerial representative on matrimonial real property from 2007, in her report, and this touches a bit on Madame Odette's concerns raised about the difference in resources, on page 75 in her report, she says if First Nations governments are to be looked to provide rights and remedies comparable to those available under provincial and territorial laws, while taking into account the distinct nature of the land regime in First Nations communities, there must be a comparable scope of recognized jurisdiction, resources, capacity, and institutional development. Otherwise, First Nations will be placed in a catch-22 situation. They would be held to the same standard as provincial governments, but not have the resources and capacities to achieve it. Have either of your departments done an analysis on the gaps between what is available to First Nations on reserve versus what would be available in terms of legal aid, access to police officers, ability to enforce these? Have you done that kind of analysis on this legislation?
Listen, this is a question that has been certainly considered in the department, and of course, we are always analyzing what the capacity is. And there are certain communities where there is no capacity issue. Others there are.
So
that's why we trust that the Center of Excellence will be a useful tool to
Minister,
help
forgive
address.
me.
Can I answer the question?
No, well, actually, you're not answering my question.
Can I answer the question, Madam Chairman? So the Center of Excellence, we trust, will be able to help those communities that may face more difficulties into implementing this kind of legislation. But what we must not lose sight of is the fact that if a First Nation does not have the capacity, the federal rules will apply. At the end of the day, those women, those children, those couples living on reserve will get the same protection as other Canadians have.
Mr. Minister, forgive me. My question was not to do whether or not First Nations needed support in terms of developing custom codes. My question was whether or not your department has done the analysis on whether First Nations will have the capacity to actually enforce S2 once it's passed, whether they will have the capacity to provide support around transition houses, because we know that oftentimes people are faced with a difficulty when there's been some dispute between partners, whether they'll have the capacity to provide legal aid. Those are the questions that I was asking you, not whether or not they would have capacity to support development of custom code.
5 seconds at the most.
Listen, I will candidly admit that I am not in a position to answer that question because I'm newly appointed here and I do as best as I can, so I undertake to answer the question in writing if it satisfies you.
Okay.
Thank you.
Thank you. Ms. Ambler?
Thank you, Madam Chair, and thank you, ministers, for being here today to talk about this very important bill. And so we've been talking a lot about consultation today, and I think, frankly, I'd like further elaboration, Minister Valcourt, if you wouldn't mind, because I think that Canadians need to know that there has been adequate consultation. So can you tell us the consultation process and the way that Bill S2 has been amended to respond to the information gathered in that consultation process?
Okay, well, and at the risk of repeating myself, this legislation responds to calls for action over the last 25 years from Aboriginal women, international organizations like Amnesty International, parliamentary committees. As I've indicated, the province, the Legislative Assembly of Manitoba have urged us to pass this legislation. And again, this has been going on, at least on our watch, since 2006. As Minister Ambrose has indicated, this is the fourth attempt at passing a bill that would fill this gap. We initiated back in 2006 extensive consultation process that included over 100 meetings at 76 locations across Canada, and helped us lead us to the legislation that we have before us today.
Great. And I'm sorry.
Go ahead.
Could you elaborate on the amendments that were made as a result of those consultations?
Yeah, and that's an important point you raised, because indeed the bill has been improved as a result of these consultations. For example, some of you may remember about the verification process that was contained in the original bill. Well, this has been removed. The First Nation Council is now responsible for reporting the community approval outcome in writing to the minister if the First Nation law is approved. So its removal eliminates confusion and misunderstanding about the role of the verification officer and addresses the concerns expressed by First Nations and Aboriginal groups that this process was paternalistic. The other change is the ratification threshold, which has been lowered. There was a double majority required for the adoption of First Nation laws, which meant a majority of the eligible voters had to participate in the vote, 50% plus one, and one of those, and of those, a majority had to vote in favor. This has been lowered. The ratification threshold now requires a single majority vote with a set participation of the vote at least 25% of the eligible voters. The third change is the transition period, which has been added. I mean, before, upon royal assent, this became law. A 12-month transition period was added before the federal provisional rules comes into force, and the government recognized that some of First Nations are well advanced in developing their own laws, and the transition period provides time to enact their laws under this legislation before the provisional federal rules take effect. So First Nations, as I said earlier, are not limited to the 12-month transition period to enact their community-specific laws, but they will start applying on the day that the federal the federal rules will apply.
Thank you. How much time do I have left, Madam Chair? Sorry? When you talked in your opening remarks about how incredulous you were that there is opposition to this, I have a feeling, and Ms. Bateman referred to it as well, I have a feeling you were referring to some of the misinformation that's going around, the myths about what this legislation does or doesn't do. Could you clarify for us the involvement of the ministerial representative, and because some are saying that those suggestions were not incorporated into the proposed legislation?
Well, I mean, when I talk about my incredulity and consternation, it is, on a une expression en français.
We have an expression in French. I don't know what the interpreters will say, but in French we say, you try to drown the fish, literally, but you're trying to sweep it under the carpet or avoid the issue.
Not that I'm not saying that these other questions are not important.
The time is up, Mr. Minister. Sorry.
But this is fundamental.
Yeah. Next, Ms. Day.
Actually, I'll be sharing my time with my colleague, Ms. Day. I want to note that my province of Manitoba has been referenced many times, and I wish the First Nations of Manitoba received the same kind of adoration and certainly commitment as the province is being heralded with today. But I do want to read into the record the part of actually the final paragraph of the Attorney General's speech from Manitoba, where he says, "So we have concerns about process. We have concerns about certain provisions, and we certainly have concerns about the supports to make Bill S2 work. We want to fill a legislative void. Let's call for improvements to Bill S2. Let's do that today." Mr. Speaker, thank you very much. There is and I've certainly had the chance to speak with colleagues who've noted support in principle, but have expressed real concern about various provisions, including the kinds of supports that provinces will need to go forward if this bill were to be implemented. And my question is, and again, a yes or no answer would be preferable, was there a consultation done with every single one of the provinces?
Well, in answer to the question, I'd like to read, because it was sent to the Minister of by my good friend, the Honourable Mr. Robinson, the Minister of Aboriginal Affairs, Aboriginal and Northern Affairs in Manitoba, and it reads as follows: "Therefore, be it resolved that the Legislative Assembly of Manitoba urge the federal government to pass Bill S2, Family Home Zone Reserves and Matrimonial Interest or Rights Act. And therefore be it further resolved that a copy of this resolution be sent by the Speaker to the Federal Minister of Aboriginal Affairs and Northern Development. So, and there was no qualification in the call by the Legislative Assembly of Manitoba to endorse.
It was a private
Bill
member's bill
S2.
by the leader of the Progressive Conservative Party. So, in fact, the letters, the actual words of the resolution were the words of the Progressive Conservative Party in Manitoba. But my question, which you didn't answer, is was there consultation with each of the 10 provinces?
Again, can you help me here, Carl?
Yes. Can I,
Yeah.
Madame la
This is
Présidente?
Carl Jacques,
Yes.
an official with our department.
The provinces have been consulted and have commented on the draft bill when it was in development.
Okay. Has there? Can we get a briefing on that?
I'll have to get back to you on this question.
I mean, it seems obviously pretty critical given the impact of this legislation on the provinces. And has there been an analysis of the cost that will be incurred on provincial legal systems?
I am not in position to answer that question.
Is anybody else in position to?
Well, I can probably give you the cost of violence against women on
No, actually,
First
my
Nations,
question was
and that's
about
one of the issues
legal
why
cost.
this needs to move
Minister
forward.
Ambrose, I mean, I certainly appreciate sort of, going back to the broken record here, but the reality is that people, I'm sorry, this is my time to address the fact
to the question.
that
Keep moving. You only have a few seconds.
Excuse me,
You were
Madam
going
Chair,
to,
I am keeping to the question.
And you were going to
The
share
point
your
that I
time.
would like to raise, and it ought to be on the record, is if legal systems do not have the resources, whether in terms of legal aid, whether it's in terms of allowing courts to access remote communities, there is no access to justice. And I think that is something that we clearly haven't heard from this committee. My last question is, would you be open to amendments to Bill S2?
Well, if if there, I mean, this has been amended a number of times, and the committee is master of its own procedure. So it's not for me to say whether or not the committee would
So you are
welcome
open
or
to
not
amendments?
But listen, I mean, I'm a very practical person. If there are amendments that can add to this bill without affecting its execution or its principle, we'll look at it. But I think that after so many years with so many groups, so many people having looked and studied and discussed and debated this bill, I trust that it can pass as it is. But who am I to say that you can come up with a beautiful amendment that would solve all of the problems of the world? I mean, if you talk about legal aid, it's not in the ambit of the bill. If you talk, we're talking about the basic rights. And
5
I don't
minutes
see what
is
I've
up,
got to
Madam.
be added. Thank you.
Moving right along to Ms. Crockett.
Thank you very much, and thank you very much to both ministers for coming here and appearing before the committee. And also, I want to commend you for this very much needed and long-awaited bill. The reason why we're here today is because we believe that it is absolutely unacceptable for Aboriginal women not to have equality with other women in this country. And I think it is important that we state that moral cause, because I find it particularly shocking that the women across the table here from the NDP and Liberals are holding back what is a very important step for Aboriginal women's rights. And I have some particular background in this because my mother started one of the first women's shelters in Alberta, and by far the majority of the women who were left destitute and homeless after spousal violence were Aboriginal women. And, to be holding this back at this point based on, methodology, and, we want you to consult with every single reserve in the country when it's been 25 years, $8 million, 103 communities consulted with, I find shocking. So I'd just like the minister and whomever feels that they can properly address this, that one of the most important things we've heard today is that emergency protection orders save lives. I think we are talking lives here. The journey of 1,000 miles begins with a single step. This is, in my view, a very good single step forward. But I think we should make it clear. I'd like to hear, how will this bill save lives?
Well, it's interesting the point you made about shelters, because there's been a number of witnesses before the committee that studied us and on this particular issue. And one was JoJo Marie Sutherland, who's a staff member at the Native Women's Transition Center, and she appeared before committee in January of 2011, and she said, quote, on the reservation in the 70s, family violence was an everyday thing. You married the guy and you had to stick with the guy. The band house gets given to you. The band house does not belong to the female, belongs to the male. If you decide to leave, then you're leaving the house, and that's what happened to me. So she talks about the real practical issues that women are faced with when predominantly the man has title to the house. And so if he's able to sell the house without her permission and keep all the money, or ban her from the house, or no judge can order an emergency protection order to remove him from the house if there's spousal violence, I mean, it's just, you can only imagine, as someone who is familiar with the shelter system, what that means for women. And this really is a question of justice. It's justice for Aboriginal women and children who do not have the right to protect themselves in these kinds of situations, when either it's a situation of family violence or a dissolution of the marriage. So without this proposed legislation, Aboriginal women cannot go to court to seek an exclusive occupation of the family home or apply for an emergency protection order while living in their family home on reserve. This bill does not propose anything new. Rather, it will provide access to the same rights. So it's not different. It's just providing the rights that we all have access to and the legal protections on reserve that are already available to every other woman in this country. The current situation provides no legal certainty on the dissolution of the marriage. And, of course, Bill S2 will allow individuals on reserve to apply to the courts to negotiate the division of their matrimonial real property. We understand that Aboriginal women on reserve are often in remote areas. We know that, with limited access to the courts and not transportation. And importantly, the issue around emergency protection orders is acting quickly and needing to enforce and apply an emergency protection order quickly. And then this bill does one thing that's unique. It allows an emergency protection actually to be done by phone or emails because of the remote locations. So a peace officer or any other appropriate person can apply on behalf of a spouse or a common law partner that way if they live in a remote location. In a situation of abuse or violence where it's often dangerous to signal an intention to break off the relationship or to seek the protection of the police, the ability to have a peace officer or other appropriate person make the application for an emergency protection order can keep the victim from having to confront the violent spouse and possibly placing themselves in further danger. So again, very important for the protection of women. Perhaps it's something that Minister Velkour will speak to in more detail later, but Bill S2 also provides for the creation of the Centre of Excellence, which he's alluded to a number of times. And I recognize that implementing any legislation where there is a great deal of capacity will require support. And we're committed to that. We're committed both in our department and Minister Velkour's department to support women that need access to building this capacity, to communities that need to build this capacity. But at the end of the day, we need to move forward.
Thank you. Moving right along to Ms. Young.
Again, I want to thank the ministers for being here today and for providing us with such a comprehensive overview on S2. I used to work on the downtown east side in Vancouver, where I was a Native youth and family worker. And there I saw the effects of not having S2, where women and children were routinely on the streets because they were not able to stay in their matrimonial homes. So I also believe that this is a very important bill, and one whose time has come, and one whose importance, I think, as we've heard today, in terms of saving lives, creating safe places for women and children to stay in, as well as giving rights, equal rights to women. I wanted to ask the Minister of Velkour about the Centre of Excellence, because in my work there, as well as over the many, many years that I've done policy development and program development for different levels of government, we recognize that, indeed, building capacity is very, very important. So therefore, I was struck by the addition of the Centre of Excellence, which I think is a brilliant idea. It's not a presupposed formula. And so that Centre of Excellence is there to assist and support the various communities and First Nations to implement their own laws and act, and where that doesn't it doesn't happen within a certain time frame, my understanding is that the federal rules will apply. So I'd like to ask the Minister about how this Center of Excellence is going to transfer the knowledge, information, education about rights to these various communities across Canada, and also create the Center of Excellence to provide links, supports, program expertise, all of the things that the opposition members are talking about, to provide access to all those things, to existing experts, program services for those women and children that so need this S2. Thank you.
Thank you, and just to clarify an earlier answer in regard to legal aid, I mean, right now, legal aid, as you know, is provided at the provincial level by all provinces, and there are federal transfers to the provinces for these legal aid systems. And if you look, for example, at many provinces, whether it be Ontario or New Brunswick, the family services that are available to women in need are available indiscriminately. I mean, if you are on reserve, off reserve, they get the same service. The only thing is that on reserve, they have no rights. So on the question that you raised about the Center of Excellence, this will be established, hopefully, within an existing National First Nation Institute or organization, and will operate at arm's length from the government of Canada and the First Nations seeking its services. The Center of Excellence will support, as I said earlier, First Nations in developing their own matrimonial real property laws, in implementing the provisional federal rules, and in providing assistance with creating alternative dispute resolution mechanism. And I ask members of the committee not to underestimate the genius of First Nations in Canada. I mean, everyone takes for granted that, it will be high-priced lawyers who are going to settle this. There are many First Nations where a council of elders can be used to solve many of these issues, as long as those rights are acknowledged and recognized. So don't underestimate the potential and the genius of First Nations in Canada. We have an implementation plan for this legislation that will call upon my department, upon the Royal Canadian Mounted Police and Public Safety Canada to play into the implementation, so that we have a public education and awareness campaign, that the Center of Excellence is another aspect of this. We will have training and education for key officials at the provincial level, including police officers on reserve and provincial superior court judges. And, I mean, this is not something that we are just throwing there irresponsibly. There is an implementation plan to ensure that finally Aboriginal women, Aboriginal spouses, couples on reserve enjoy the same rights that too many of us take for granted.
I'd like to direct this next question then to Minister Ambrose.
You only have like 5 seconds.
Oh. I guess I would like to say that the Center of Excellence sounds like a very fluid model that can be therefore used to direct this S2 and how it's going to sort of evolve and be integrated into the various communities to give women and children these rights.
Thank you very much for your attendance here this morning. And we will now go in and move and have the room cleared for the move-in camera for our business meeting. And we thank you very much. So we will return in a few minutes for our business meeting.